come here today, and I'm so excited about it. And I see the faces that I haven't seen for a long time. So thank you so much for coming. And with the idea of the trust seminar, had a client in December, and we closed escrow, and I asked her, I said, so do you have a trust? And you need to put your home in a trust. And she's like, what is that? So that kind of sparked, the idea. It's, some people might not know about it. Some people might have questions about it. And how do I eat it, right? So that was an idea, and we always love to serve the community and our clients. So this is it. So I'm not going to be talking. I'm not a great speaker. But I've got somebody who knows everything and is going to answer all your questions. And I also have my great friend Kevin Kelly. He's a title representative. So he's going to be queuing us some new tax laws and stuff like that. So he's coming. He promised. But he's stuck in traffic. So some of you, I think you talked to Kevin before. So anyway, I want to introduce our attorney that is going to be in charge of today's talk, and his name is Brian. So warm welcome, and take it away, Brian.
All right, thank you so much for having me, Kathy, and thank you so much for all of you for being here. I wouldn't judge Kevin too harshly, right? We're Southern Californians, and it's rained today, so.
Exactly.
So, can you guys all hear me over there in the back? Hello. Good. Perfect. So, here I'll slide over a little bit. Yeah. So, perfect. So. So very nice to meet you all. Just a brief introduction. My name is Brian Chow. I am a asset protection and estate planning attorney. So what does that mean? So what I do is I help my clients to structure their assets to make it more difficult for people to sue them, and then ultimately to pass those assets on to their loved ones or their charity in a way that minimizes their taxes and their headaches, and also maximizes whatever their legacy goals may be. And so the goal of today, as Kathy was saying, was to teach you guys a little bit about estate planning, what it is, how it's relevant to you, and answer your questions, and maybe make you a little bit more educated, a little more fun at holiday parties or cocktail parties, and also maybe to spark some ideas as to how you might want your estate plan to look, or how you might want it to change to better align with your intention, right? So without further ado, I'm going to dive in. A couple housekeeping items is you have, I think, on your chair or with you my bio, so that tells you a little bit about me. All my contact information is on there as well. So if you wanted to contact me afterwards, that's there for future reference. My cards and also pens are here as well. So if you want some of those, feel free to come up and grab those afterwards. Another important thing is there's a seminar response form there. So if you wanted to provide me with any feedback to help me to be a better attorney or a better speaker in the future, that would be much appreciated. And if you also have additional questions for me, or you want to talk about your situation specifically, you can fill out your information on the seminar response form and send it back to me at the end of the meeting, and I will follow up with you for a one-to-one conversation. So without further ado, let's dive in. So estate planning, that's what we're all here to learn about. And let's start by talking about what an estate is, because you hear the word estate, and for some people it may make us think of let's say Downton Abbey. You guys ever watch that show? You know, we're all in an English manor on the countryside. We go fox hunting, we take tea, we have 20 servants, we have a hedge maze right in our yard, and we may think, I don't really have an estate, right? But the truth of the matter is your estate is really everything that you've worked for over the course of your lifetime to accumulate. Think about things like your house, your bank accounts, your investments, your rental properties, your businesses, your life insurance, your collectibles, your baseball card collection, your guitars, right? Your purse collection, right, for the ladies. And so that's all of the things that we've accumulated during the course of our lifetime. And estate planning is really about how do we control what happens to our lives and our assets in the event that something happens to us and we no longer have the ability to make those decisions from day to day as to how our lives and our assets are to be run and managed, right? So specifically what we're planning for death or incapacity, right? You know, back in the olden days, right, you might get eaten by a tiger and there it is, right? But nowadays, with modern technology, right, people oftentimes don't pass away so suddenly, right? We may stick around for a while, but may not have full ability to make decisions or good decisions with regards to how our lives are supposed to be run, right? Think about, you know, Alzheimer's, dementia. We might be in a coma. We might suffer a stroke, right? And so in those situations, you know, our decision-making ability may be diminished. And so, and same thing, when we die, same deal, right? And so when that happens, if we don't have a plan in place, guess what? Our loved ones have to scramble and they have to try to figure everything out. And there's a lot of negative consequences that can occur when we fail to plan. One very obvious one being, if we don't let people know what we want oftentimes doesn't get carried out because our friends, our family, our loved ones, they all have their own personalities, they have their own life circumstances. Some may be rich, some may be poor, some may be greedy, some may be altruistic, some may have all the time in the world, some might have 3 kids and can't think straight, right? And so beyond that, there may be other stakeholders too, right? There could be co-owners of real estate, there could be business partners, tenants, creditors, the government, all pulling in different directions. So we want to be really clear in articulating what our wishes are, one, so that everyone can recognize those wishes and operate off the same playbook, right? And then ensure that those wishes are then carried out, right? We're essentially speaking those wishes into existence, right? And so another goal that clients have is they want to minimize the potential for conflict. Obviously, it can be very stressful and emotional when somebody passes away. It's also a time that most families have very little experience dealing with, both from a personal perspective and even more so from a legal perspective. And so, if you can imagine, we take a bunch of assets and we plop them down into the middle of a situation, which is one, very emotional, and number two, very uncertain. Guess what can happen? The claws can come out pretty quickly, right? And so that's something that clients don't really like, is they don't really like the idea of their loved ones suing each other in court, or siblings or cousins not talking to one another for years or potentially decades because of hurt feelings or issues that occurred during the administrative process. So that's something, again, we don't really like, right? So one of the ways that we mitigate that risk is we want to be really clear in laying out what everyone's rights are. So who's in charge, where is everything supposed to go, how is everything supposed to be delivered, so that we leave very little wiggle room for people to argue about things and to misinterpret things. But even when people do disagree, guess what? We now have a framework to resolve those conflicts. Much better result, usually. So another goal that clients have is they also want to make life as easy as possible for their loved ones, right? So ideally, we'd like for the people that we appoint to be able to easily step in, understand what our wishes are, and then carry those wishes out with a minimal amount of time, effort, and expense. And so one of the big impediments to that is something called probate. Anybody ever heard the term probate? Anybody ever have to deal with a probate in the room? No? Lucky you. So probate, in a nutshell, is basically a court process by which title transfers from somebody who's passed away to wherever it is that the court believes that the assets should go. And the reason why probate exists is primarily for one very simple reason, which is most people, when they acquire assets, the easy and the natural thing to do is to acquire those assets in their own name, right? So for example, how many of you are homeowners? Okay. How many of you own your home in your own name, right? So that's an example, right? So the easy thing and the natural thing to do when we acquire assets, right, we're taught, okay, put your name on it, because that's what gives you ownership over those assets. So let's say I buy a house that says Brian Chow on the deed, right? That means I'm the legal owner of the property and I get to do with it what I want. So if I decide, in this case, that I'm going to sell the property to Nick, right? Did I remember that correctly?
Mm-hmm.
So Nick, or maybe Nick and Ivy, right? They're a lovely couple. I want them both to enjoy it equally. I signed a deed. I transfer it over to Nick and Ivy, and that's their property now. They get to do with it what they want. I decide instead that I want to remodel the kitchen, right? I hire a contractor, go for it, put on the rainbow backsplash, perfect. I decide I want to get a loan, right? I go to the bank, I get a loan, great, right? And that works really, really well while I'm alive and able to make decisions. The problem is in the event of my passing, Brian Chow, the individual, is deceased. So I have no actual authority to make any decisions. But according to the documents, I'm the only person with any legal authority because I'm the one entitled to the property, right? And so since nobody else in the world is me, no one else can do anything with that property. It's just sitting there. It's not being lived in, it's not being rented out, it's not being productive. So at that point, it falls to the state to figure out what to do with my stuff. So the probate court is the arm of the state of California. They come in, they gather up my assets, they figure out what did I have, what debts did I owe, make sure my creditors are paid off, and then eventually a judge is going to then try to step into my shoes and determine what it is I actually wanted. So the judge will look at things like, did I have a spouse? Did I have children? Did I leave a will? Did I leave a trust? Were there any other circumstances or documents which would give some sort of indication as to what I actually wanted? Eventually, the judge is going to say, okay, having reviewed all facts, this is what I believe Brian wanted. I hereby declare that everything gets distributed in this manner. Slams the gavel, my loved ones can then take ownership, and then they can do what they need to do. But in order to get from point A to point B, we got to go through this long, drawn-out court process, which is one, very expensive. Number two, it takes a long time. And number three, it's public. So for those three reasons, people typically don't like going to probate, right? They don't want to spend tens of thousands, or in more extreme cases, hundreds of thousands of dollars transferring assets that they could have transferred for a lot less money and preserved for their loved ones. They don't want their assets to be stuck in court, which in Southern California, 2 years is probably, for the smoothest of probates, it's probably pretty good. And then certainly more than that if there are complications. And so thirdly, because it's public, people don't want any Tom, Dick, and Harry off the street to be able to see what kind of assets they have and where those assets are going, right? So again, for those three reasons, people typically don't like probate. So one of the ways that we avoid probate is with something called a living trust. Anybody here ever heard of a living trust before? Yeah. Anybody here have one? Yeah. Nice, all right, I like it. So a living trust is one way that we avoid probate. And the way that I like to explain how a living trust works is by comparing it to a will. Everybody here has heard of a will before, right? So a will and a trust are oftentimes confused for one another. Or people assume that they're synonyms, right? They're the same thing. A will and a trust are the same thing. But they're not. And this is what's going to make you a hit at cocktail parties, is I'm going to tell you the difference between a will and a trust. So a will, you can think of like a letter that you're writing to a judge. You're basically saying, dear judge, when I die, all my stuff is going to end up in your courtroom, and this is what I want you to do with all of my stuff. Here's how you divide everything up. So a will is good in the sense that you are speaking your wishes into existence, right? You're articulating what you want to happen, but it's all designed to happen through the court system. So it's like being on the 405 at 5 o'clock, at rush hour, right? Just like Kevin was driving over here. So that's bad, right? Because the court system, right? When you're going through the court system, that's the most obvious place where everyone who hasn't planned well ends up, right? And so it's kind of like the state has limited infrastructure, just like the 405, and everybody's cramming on at rush hour, right? There are costs associated with that because it's a pain, costs a lot of money, takes a long time, right? So that's probate, right? It's designed, your will is designed to go through probate. With a living trust, what we're doing is we're doing something different than that, right? We're instead of just writing a letter to a judge, what we're doing is we're creating a separate legal entity from ourselves. So you can think of it almost like a company, right? So I create this trust, this company, we'll call it the Chow Family Trust, right? Keep it nice and vanilla. And so now we have the Chow Family Trust, which exists over here, and I'm over here. So two separate beings, right? And so instead of me owning everything in my name, what I now do is I take ownership of my assets and I now transfer them to the Chow Family Trust, right? So my house is now owned by the Chow Family Trust. My bank accounts, my investment accounts, my rental properties, my LLCs, my businesses, my life insurance, right? It's all held and owned by the Chow Family Trust. So now you may be saying, well, isn't that a little weird, Brian? Like, now you don't own anything. And that is a little weird, right? Because we live in an ownership society. Like, if we don't own anything, then what's the benefit of all this stuff? And the good news is even though I no longer technically own these assets, I'm still I still have control of all those assets, right? Because I'm the trustee or the president of the company, right? So everything is owned by the Chow Family Trust, but I'm the CEO, right? So I still get to direct the trust and what it does. So if I decide I want to sell the property to Nick and Ivy, I can do so, right? If I want to take out a loan, if I want to refinance, if I want to remodel the kitchen, right? All the things I would normally do as an individual, I can still do. But now I'm wearing a different hat. Gentleman in the back with the stylish hat. What's your name? Richard. So I've got a hat like Richard, right? I'm swapping it. I'm no longer Brian Chow, the individual. Right now I'm putting on a top hat, right? So instead of me acting as Brian Chow, the individual, I'm now acting as Brian Chow, trustee of the Chow Family Trust. So I'm acting in a slightly different legal capacity, but I still have all the control to do whatever I want during the course of my lifetime. So now what happens is Brian Chow dies, right? I passed away, sadly, but heroically. What happens then is I didn't own anything, right? So there's nothing to probate because Brian Chow, the individual, is the one who passed away. Brian Chow, the individual, doesn't own anything, right? Everything continues to be held in the Chow Family Trust, which is still existing even though I'm no longer around, right? It lives on even though I'm not around. And I had the foresight within my living trust to appoint successor trustees or vice presidents, right? And so let's say that I appoint, I don't know, we're going to pick on Kevin. Let's say I appoint Kevin as against my better judgment, I appointed Kevin. And Kevin is my successor, right? So if I'm gone, now Kevin would now step up into my place, and now he would have the legal authority to then carry out the terms of my trust. So let's say that my trust says my vast real estate empire gets divided amongst my sons, right? And Kevin steps in, and now he has the legal authority to then sign all the documents on behalf of the trust to then transfer all my assets from my trust to my sons. And so what we're able to do really is two important things, which is one, I'm able to appoint somebody who knows my situation, who I actually trust to carry out my wishes, rather than leaving it to a judge to make those decisions. And number two, we're able to accomplish everything outside of the probate process. So we're able to make things typically a lot less expensive, a lot less time consuming, and everything is privately administered so that the only people that have a legal right to see what's going on are going to be my natural born heirs, in this case my children, or any other beneficiaries that I choose to appoint within the trust itself. Does that make sense so far? Awesome. So now, right, let's talk about, that's just kind of like the baseline basics of why we should do some estate planning, right? We're planning for death or incapacity, and we want to get our wishes down on paper and do it outside of the court system. So we want to be on the toll road, not on the 405, right? We want to be able to do this outside of the normal system to make things a lot easier and less stressful for our loved ones. But it goes beyond that, right? A lot of times when we talk about estate planning, the focus is on the living trust. The living trust is kind of the flagship document that has all the wishes and the concerns about where everything goes, all the substantive language. But there's a lot of other important documents within your estate plan that we also should be planning for, right? And one is your guardianship appointments, right? How many of you have children? Yes? Okay. Some of you? Great. So if you have children, some of them are adults now, some of them may be minors. But if you have minor children, or if you plan on having minor children at some point, this is a really important thing to consider, right? Which is, yeah, great. I mean, your trust may say exactly where everything goes, but who's going to take care of your kids if you and your spouse are not around, right? And so that's something that oftentimes people overlook because they're so busy about trying to figure out how to divide everything up. They're not really worried about that, right? Or they don't assume. They assume that they will live till when their children are adults, but that's not a guarantee, right? So if you don't appoint guardians for your kids and you're gone, right, then what happens is the state then chooses who's going to be the person in charge. And so is it better? Do you think it's generally a better result when mom and dad, who know their loved ones best and know their children best, make those decisions, or a judge who's just kind of swooping in last minute, and this is one case of thousands that they're dealing with, is now making that decision, right? So generally speaking, we'd rather have that control and make those decisions, right? And so that's an important decision and an important document that you would want in place as part of your estate plan. Another important one will be your incapacity documents, right? So again, death is kind of like the big focus when we're talking about estate planning. What's often overlooked is incapacity, right? If you're incapacitated, who's going to manage your finances? Who's going to make your healthcare decisions, right? We've all been, or maybe we've seen in movies, hospital dramas, or Succession on HBO, right, where somebody ends up in the hospital and all the loved ones are now battling over control of who gets to make the decisions, what doctor, what hospital, right? What procedure is going to be appropriate. And so we'd like to avoid that, right? And so having those appointments in place in your healthcare directive, right? Who's going to make your healthcare decisions? Having a durable power of attorney in place so that your loved ones can manage your personal finances if you're not able to make decisions, right? Those are also important documents that go along with your estate plan, right? And they kind of complement and work together with your living trust to make sure that all these contingencies are planned for. Another important document is something called a pour-over will, right? A pour-over will, you can think of it like pouring a cup of water, right? This is a document that also is an important component of any well-drafted estate plan. And this is a will that goes hand in hand with your trust. A lot of times people will say, hey, I already have a trust. What do I need a will for? And the answer is this, and it's kind of simple and kind of funny, right? Which is your living trust. You want to think of your living trust kind of like a delivery truck. The delivery truck will take your stuff wherever you want it to go, however you specify in the trust. However, it only delivers what we put on the truck, right? So it's important when you have an estate plan or you have a living trust that we actually title your assets in the name of, let's say in this case, the Chow Family Trust, right? So if I have a piece of land somewhere or a bank account somewhere that for whatever reason I just didn't transfer into my trust, right? I passed away and it was just held in my name somewhere. In many cases, those assets will end up in court, and a judge then gets to decide how to distribute those assets for me unless I leave instructions. And so my pour-over will is basically just an instruction to the court that says, look, Your Honor, even though I forgot to put something into my trust and I passed away, that's my bad. But rather than you getting to decide how everything goes, my will obligates you to pour those assets back into the Chow Family Trust so that everything can be distributed the way that I want, rather than the government deciding on its own how to distribute things. So this is not a get out of jail free card, right? We still have to go through this court system, right? We still have to get on the 405 for a couple exits to get this done, right? But it's better than that versus the alternative, which is a judge then just deciding where the assets go. At least in this case, your assets still end up where you want them to go, rather than a court deciding. And so, so that's another important component of your estate plan, right? So there's all these different documents that kind of act together to make sure that your wishes are clearly captured and that the right people have the ability to make those decisions. So, along with that, right, or so those are kind of like the basic components of a well-drafted estate plan, basic estate plan. But let's talk a little more aspirational.
Question?
Sure, go for it.
So this pour-over bill,
Yeah.
will capture everything that's not in the trust.
Yeah. So sorry, what was your name?
Krishna.
Krishna, right? So Krishna was saying he was asking, so the pour over will captures everything that we forgot to put into the trust, right? And he's asking me to confirm that.
Right.
And the answer is generally yes, but I'm an attorney, so there's always caveats, right? So generally, the pour over will covers any assets that you would hold in your own name that you didn't make some other arrangement for, okay? So for an example, let's just say I owned a piece of property, right? It was in my name, Brian Chow. I died. There's no other provisions that designate where those assets go, right? In that case, my pour over will would control that asset and dump it into my trust, okay?
Right.
So that's one example. Now here's another example. Let's say, and was it Anne?
Yes.
Okay, so let's say Anne and I decided to co-own a piece of property together, right? We bought a rental property in Gardena. Gardena sounds nice. You said you like
Sure.
flip-flopping between
Yeah.
Orange County and LA, right? So we co-own this property, and we own the property as joint tenants. Okay, anybody here familiar with the term joint tenants?
Mm-hmm.
Anybody married? Okay, if you're married, chances are if you looked on title to your house at one point, it probably said John Doe and Jane Doe, husband and wife as joint tenants, right? So when you own property as joint tenants, an important thing to know is that there's something called a right of survivorship in a joint tenancy. What that essentially means is the last person standing continues to own the property, right? So let's say in this case that Anne and I owned this rental property in Gardena as joint tenants. And then I died, right? My will says pour Brian's stuff into his trust. However, in this case, because there's a right of survivorship, right, that there's already an arrangement made whereby Anne would then automatically own the property after my passing. So that would trump the pour over will because the title to the property actually takes precedence over my will because I've already stated that this other thing happens in the event of my passing. Another example would be like a life insurance policy, right? So if I own a life insurance policy and I appoint Yevgenia, is that right? Right? I appoint Yevgenia as the beneficiary on that life insurance policy. Same thing, right? A provision, I've already made a provision that funnels the assets to Yevgenia in the event of my passing automatically without probate, right? So that trumps the probate process. So to answer your question, Krishna, the answer is for those things that I have held, that are held in my name, that I haven't made other plans for, those assets would then be subject to the pour over will.
So let's say there is a bank account.
Yep.
Okay. The banks make it very hard to open an account in a trust. You know, they want a copy of the trust document.
Are you making a statement or asking a question?
I'm both at the same time.
Okay.
So I'm telling you that this pour over trust has to specify certain assets or everything that's not in the trust automatically
Yeah.
goes in the pour
Got
over
it.
trust.
Yeah. So the question that I'm distilling from your statement is, sounds like Krishna has tried to transfer or open a bank account in the name of a trust or his trust, and it was a pain in the butt. Okay. Sometimes, hey, look, bankers, they're not all perfect, right?
Yeah.
Some are very knowledgeable and helpful, and others don't know anything, right? But that being said, so the point here is this, right? So if for some reason you're not able to put an asset in the trust, right? There are other ways to kind of deal with that, right? So the one is if you're not able to make a provision or get it into the trust, sure, the pour over will eventually grab that asset and put it into your trust.
Okay.
Now, that doesn't come without us going to court, right?
Yeah.
So there are ways to get around that. So for example, and this is one of the things that I help my clients with, is when we set up their trust, right? Then the work begins, right? So once the trust begins, once we've set it up, then the client's responsibility is to get their assets and to title them in the name of their trust, right? And most times it goes smoothly. But that the banker wanted to see a copy of my trust. I don't necessarily want the banker to see where all my stuff is going to go. I don't want him to know that I like one of my kids better than the other, right? So the answer to that question is, and this is a great question, is in a well-drafted estate plan, one of the documents that we prepare is something called a trust certification, okay? And a trust certification is essentially an edited version of the trust for you to give to banks or financial institutions specifically in that situation, right? So essentially what the trust certification says to the bank is, I declare under penalty of perjury that my trust exists, that it was formed on this date, that the trustees are these people, and that I have the ability to do whatever it is that I'm asking you to do, Mr. Banker. That's all they need to know. That's what they need to give to their legal department, and they are required by law to accept that in lieu of the trust. And so that's a way to get around that.
Yeah,
So aren't you glad you came here tonight?
But some of them don't accept it.
Then you put them in touch. Well, if I'm your attorney, put them in touch with me, and I'll talk some sense to them. And actually, that does happen, right? So
Yeah.
it has happened where clients will run into problems at the bank, and it's gotten to the point now where I will tell clients, look, if you run into any issues, get the contact information of the banker that you're dealing with. Just introduce them to me by email, rather than us going back and forth and you being the middleman. I can correspond directly or speak directly to that person, answer their questions, and it's not a problem. So it's either that or get a new bank, because if your bank doesn't know how to deal with trust, in this day and age, you probably need a new banker just because what's going on, guys. And you had a question. I'm sorry, what was your name?
Noemi.
Noemi. Nice to meet you.
It's exactly what happened to me.
Okay.
What happened?
So her husband passed, and her husband's work issued a check, and the check was issued to the estate of husband, Noemi's
Yeah,
husband,
Roger.
right? Roger. And so what the heck is that is the first question, and how do we deal with it, right? And so when someone dies, there is something that takes their place when they die. So think about it this way. If I own a bunch of real estate and I die, who now continues to own the property, and who can continue to transact on behalf of all that stuff,
Your
right?
wife?
Well, that's a nice guess, right? And that's a nice guess. It's not the trust though, right? So that assumes that I had the foresight to put a trust together. There's a lot of people, right? Well,
Yeah.
we're gonna get there. Well, let's forget about the trust at this point. Most people don't do anything, right? That's the most common estate plan. Most people haven't done anything and then they die, right? And so when that happens, right, you die and you don't have a will or a trust, right? Or let's say you've done nothing, right? That's called dying intestate. That's fancy legal jargon, right? But it means you died and you didn't do anything, right? You didn't make any preparations. So when you die intestate, what happens is something has to take your place to take over all the stuff that you left when you died. And it could be your wife, but it's not guaranteed that it's your wife, right? Because there's a lot of other players that come into the picture when somebody dies. What if it's the kids? What if it's their creditors? What if it's their caretaker? What if it's their best friend, right? There's a lot of interests that get involved when somebody dies, right? It's not automatic that it goes to their spouse. And we can talk a little bit about that later. So, or maybe the spouse is alive, but maybe she's incapacitated, right? That's another problem, right? And so what happens is the estate is a fictional replacement for the person who died, right? So I died and I left a Bryant-sized hole in the universe. The estate essentially is now filling that space to then figure out where all my stuff needs to go, and somebody needs to be in charge of my estate to then carry out my wishes, right? So that's essentially what the bank, Rogers' company was doing, is they issued a check to the Roger-sized hole in the universe, okay? So now let's talk about some aspirational things that we can do, right? We're not just running scared from death or incapacity, right? Let's think about going on the offensive, right? How do we make our legacy more awesome, right? How do we set up our families our children, our grandchildren, future generations for success, right? So one of the ways that we deal with this or think about this is in how we pass these assets on to our loved ones, right? And for most people, right, if they have kids, right, that's probably their primary concern is how do we set up our children for success? And the most obvious way that parents will pass on an inheritance to their children is something called an outright distribution. So an outright distribution is just this. Hey, little Timmy, here's a check for $1 million. Go do what you want, right? Pretty straightforward. Pretty elegant in its simplicity, but it is not without its problems. Let's say little Timmy is 15. Do we want little Timmy to be running around with a bunch of money, right, at 18, doing whatever he wants? For some parents, that may be okay. For other parents, most parents, the answer is probably no. Like, probably don't want you running around doing all sorts of crazy stuff, right? So another concern is, well, let's say Timmy is an adult, and let's say Timmy is very responsible, a good decision maker. What other issues might parents be concerned about? One is, hey, if we're leaving all these assets to Timmy, how exposed are these assets to any problems that Timmy may have in the future? What if Timmy's going through a nasty divorce? Good decision maker, but unbeknownst to him, he married a gold digger. I don't know, right? What if, let's say Timmy is an orthopedic surgeon and he has a lot of risk and liability associated with his life. He may get sued for malpractice, right? How exposed is his inheritance to his liability, right? A third one, and one that probably no one in this room is really thinking about, is estate taxes. Anybody here a multimillionaire? Anybody here want to announce it to the room? Right. So let's just assume that there are some closet multimillionaires. Right? So there, or if you have closet millionaire friends, multimillionaire friends, you might think of them. You might let them know, Brian Chow, he can help you. But so here's the thing. So this is another thing that probably no one's thinking about, are estate taxes. Not state taxes, estate taxes, okay? Estate taxes are taxes that the government places on your assets when you die. So think about all the taxes that you pay during the course of your lifetime. Right? You pay income tax, you pay sales tax, you pay capital gains, you pay property taxes, right? And on your way out the door, boom, the government sticks it to you one more time, right? So the government says, okay, when you die, we are going to figure out the value of everything that you own, and we're going to come up with a number. Whatever that number is that you're passing on to your loved ones is subject to this tax. The bad news is the current tax rate, 40%. Bad, right? Before you fall out of your chairs, the good news is that most people don't have to pay this tax. Say again?
I was just telling her we wouldn't fall into that anyway. It's $100 million or something.
No, it's not 100 million, but
If you have
We'll talk
5
about it.
million, so
it used to be 5 million. But so here's the good news.
Right.
Most people don't have to pay it because, and I'm sorry, I didn't catch your name.
Katie.
Katie, as Katie was saying, right? Most people don't have to pay the tax because the government gives us an exemption amount. So there's a certain amount that we can protect of our assets before this tax applies. The current exemption amount is a little over $12 million. Wait for it, per spouse. Okay, so if you have the per spouse. So if you have the good fortune to be married, then right between you and your spouse, if you pass away with the current laws in place, you can pass on roughly $24 million in change without incurring this estate tax, right? If you're married or if you're single, right, then you have $12 million, right? So for most people, they might say, woo, wow, dodged a bullet on that one, right? Don't have to worry about estate taxes. I can just keep making money, no problem. So the important thing to know, though, however, is that, one, the estate tax laws change, okay? So to give you an example, back in the 90s, the estate tax exemption was $600,000, okay? Now it's $12 million, right? In between, it's been $1 million, it's been $5 million, it's been $2 million. It kind of hops around based on the whims of Congress, right? So when we have Democrats in power, they want to shrink that exemption. When we have Republicans in power, they want to expand that exemption, right? And so, so it's not guaranteed that you won't have an estate tax issue, right? The other important thing to consider is even if your assets don't rise to the level of the estate tax today, the important thing is not where you are today, right? Wayne Gretzky, the great hockey player, right? He had a saying, which is, I go to where the puck is going, not to where the puck is, right? And so it's the same thing, right? Where are you going? Where are you projecting forward, right? If you're like Nick and Ivy and you're in your early 20s, is that right?
No.
Right? And you're already millionaires. You're gonna, chances are you project forward on that, time versus wealth continuum, right? That you're gonna have an estate tax issue, right? If you're in your 80s and you're worth $5 million, right? And you're in poor health, probably not as big of a deal, right? But that's part of the consideration that we have as an estate, when we get into estate planning, is where are you likely to be relative to what the estate tax exemptions are likely to be when you pass away, right? And so, to give you an example, right, of the laws changing, the current law, the current estate tax exemption is set to change. Not because Congress is doing something, but because Congress is likely to do nothing, okay? So the way that the current, which is, they're great at that, right? And so Congress, right, when they passed the last law, said, okay, this law will expire at the end of 2025. So that $12 million exemption at the end of 2025, assuming that Congress hasn't done anything, gets cut in half. So it goes from $12 million to $6 million, right? So if you're, again, if your multi-million-dollar friends are out there talking about their net worth, then you might want to say, hey, just be mindful, right? In 2025, all these estate tax laws are changing. You might want to get on some planning there, because if we plan properly, time is our friend, right? And so you don't want to be doing this planning on your deathbed, right? If you can project far enough and be proactive in your planning, you can structure your assets much more favorably so that we can pass on the majority, if not all of your assets, to your loved ones without being subject to estate taxes, okay? So now we know what estate taxes are. So let's circle back to Timmy, right? So remember, we were going to give Timmy $1 million, and we were concerned about, one, Timmy blowing all the money. Number two, Timmy losing the money due to divorce or creditor issues, and then also to estate taxes, right? And so let's talk a little bit about how we might aspirationally plan to protect those assets better for Timmy and maybe Timmy's children or grandchildren. So instead of just cutting Timmy a check, one thing that we oftentimes do is we'll utilize something called a separate share or a lifetime benefit trust, okay? And essentially what that is we say, okay, Timmy, instead of leaving you $1 million in your name, we're gonna leave these assets to you in trust. So Timmy gets a little sub-trust that pops out when mom and dad pass away. So if you guys ever watch like Star Wars, you know how when the big spaceship's gonna blow up, little escape pods start popping out, right? That's like that, right? So this is like a little escape pod. It pops out and it holds Timmy's inheritance. So the good news is the assets are held for Timmy's benefit. The assets have to be used for Timmy, but Timmy doesn't own those assets, right? So the benefit there is now, let's say that we still wanted Timmy to have control of the assets at a certain age, right? Not at 18, maybe 30, right? So let's say in this case, we'll pick on Anne again, right? So we have Anne, my roommate. Anne is now the trustee for Timmy's trust until he turns the age of 30, right? So what that means is when Timmy's 18 and he wants to put spinner rims on his Hummer, his H2, right? Then Anne can say, nah, that's probably not a great use of your money. We're gonna just not do that. But now Timmy gets his act together and he gets accepted to, let's say, Pepperdine Law School. Any waves out there? No? Pepperdine Law? Okay. So Anne can then say, "Oh, of course, I will pay your tuition. That's in line with what your father wanted. Here you go." Right? And so at 30, right now, Timmy, we can give Timmy the ability to act as trustee of his own trust. Right? So he then says, "Step aside, Auntie Anne. I'm now taking over. I now get to make decisions. I will avoid buying spinners for my Hummer because I'm now old enough to make good decisions." Right? So now he takes over. Great. At 35, Timmy gets divorced. Right? Timmy's wife is coming at him full force. But guess what? Timmy's inheritance, it's segregated from the communal assets that Timmy has with his wife, right? It's not blended together, it's not commingled, it's not a joint account, it's not something that his spouse has access to and that his spouse can draw down prior to filing for divorce, right? It's also clearly marked as an inheritance from mom and dad, so it's also very clear that none of these assets were meant for Timmy's wife, and thereby, in the event of a divorce, the likelihood that she would be able to make a successful claim for any of those assets is negligible, right? Another scenario, Timmy gets sued. He gets into a car accident, somebody sues him, and again, they're coming after his stuff, right? If Timmy owned that inheritance in his name, that's fair game, right? His creditors can reach those assets. But in this case, again, because those assets don't technically belong to him, right, they're held in a separate trust, and that trust says these assets can be used for Timmy's benefit. They are explicitly prohibited for being used for Timmy's benefit, right? And so they're your assets to make the rules on, right? So mom and dad got to make the rules because mom and dad made the money. So mom and dad said, "Hey, we are not just giving this to Timmy. We have certain restrictions placed on how these assets must be used," right? So that also further insulates those assets from Timmy's liability. Thirdly, estate taxes. Timmy, remember, Timmy is now an orthopedic surgeon. I don't know how he did that having gone to Pepperdine Law School, but he's an orthopedic surgeon. He's worth a lot of money. And so Timmy has several tens of millions of dollars to his name. And mom and dad don't want to just say, "Hey, here's $1 million more to dump on your pile," right? That would then get taxed when you die at 40%. And it's not only that $1 million that gets taxed at 40%, it's all the appreciation on that $1 million over the course of Timmy's lifetime, right? So if we're talking 40, 50 years, that $1 million could be 10, $20 million, right? Maybe that, so depending on how Timmy invests it, but as an orthopedic surgeon, you probably get a pretty good financial advisor, right? So the idea then is we don't want all that to be taxed at 40%. If we segregate those assets, then those assets get to grow for the course of Timmy's lifetime without adding to his estate tax bill, which is an additional chunk of money that can pass to the grandkids, right, and further their lives and their well-being without being diminished by taxes.
What
So
is this trust called?
it's called a lifetime benefit trust or a separate share trust. So one thing that you might know about attorneys, or that you might learn about attorneys, is some attorneys are very technical. Other attorneys will do anything to make something sound sexy to sell it to you. And so you may out in the world hear all sorts of different names for this type of trust, but the technical term is a separate share or a lifetime benefit trust. Yes?
Does that bypass Prop 19?
That's a great question. What was your name?
Terry.
Terry. Terry had a question. Does that bypass Prop 19? Does everyone here know what Prop 19 is? Okay. So this is going to turn into a whole other discussion. So the answer is no. Terry, right? So Terry's asked the question, does it bypass Prop 19? What the heck is Prop 19? Prop 19, we can't talk about Prop 19 without talking about Prop 13.
Don't stop on my speech.
Oh, okay. You want to jump in on this?
Yes.
Oh, hop in.
Here's the good stuff. What they did about 1.5 years ago was they took 5 different propositions and put them all under Prop 19. So there used to be 60 and 90. That was if you were over 55 and you're transferring your tax basis, you could do that one time in your lifetime, but your replacement house had to be equal or lesser value. You could deed properties to your kids. And there was no limits on that. You could just, if you have 4 rental houses and you have 4 kids, that's kind of was their estate plan, right? the good, and then there was, grandparent to grandchild. There was if you're severely disabled. There were a lot of these separate propositions. Well, they decided to put it all in one. And what we got was a hybrid. We got some things that we wanted, which was, so at its basis, to qualify for Prop 19, here is the basic requirements. You must be over 55. It must be your primary residence, and you signify that by filing that homeowner's exemption. And it's, you just do it through the assessor's office. We can help you with it. There's no money involved. You're just declaring it publicly that is your primary residence. And you're over 55, so you can sell that property. So I bought my house 22 years ago. And it's gone up quite a bit, let's just say. So, but my tax basis is still set at that amount that I purchased 22 years ago. So I can now sell that property, I can buy a replacement property, and I can move my existing tax basis to that because it's my primary residence, I'm over 55.
You don't look at them.
That's very nice. Botox was yesterday. So anyway, so the bottom line is, before I could only do that one time in my lifetime. Now we can do it 3 times. And they didn't keep track of if you'd already done it or not. Everyone starts from 0 because the assessor doesn't want to try to go backwards and figure out who did it and who didn't. So they also did away with the equal or lesser requirement. So if I was going to sell my house for $1 million, my replacement in the old days had to be $1 million or less. Now I can buy $1.5 million. And the only additional tax will be the prorated difference between the $1 million that I sold mine for and the $1.5 million that I bought my replacement. So that first $1 million will be at my original tax basis from 22 years ago. And then they will take the tax rate in my city and then prorate the additional $500,000. You can do that 3 times in your lifetime. And and the other thing was, there used to be each county could opt in or out. It's now the whole state of California. I do get this question. None of this applies if your replacement is in another state. Because we have seen a lot of people kind of leaving the state in the last 5 years or so. So these are all California propositions. Now, questions about that? In cases of divorce, I did ask this when the assessor was at my office, and one or the other person gets to take it. And 90% of the time, that's dictated in the divorce agreement. So, just another thing to fight over. If you're getting a divorce, who's getting that, right? Questions about that aspect? Yes.
How about when you die and your children inherit it?
So this is a great thing. In an ideal scenario, the property is held in a trust.
And it is.
So
It is.
that tax basis, there is no reason for that to be reassessed. The trust is a living, breathing entity, kind of like a company, right? So while the CEO died, the company is still valid. And the company is still taking advantage of the Prop 19. The problem would be if the assessor reaches out to the heirs to verify that they are living in that property.
Yeah, that's the difference.
Right? They're going to have to, if the kid has a homeowner's exemption on another property of theirs, you're going to want to get rid of that, and they really should move into the property. That's the law.
And they're under 55.
And then
they can still.
That's fine, because there hasn't been, the only time that the assessor, like I call it poking the tiger, you don't want to poke the assessor tiger. And the only thing that does that is the recordation of documents. Right?
Do you mind if I briefly interject there?
Yeah.
Technically, it would be a reassessable event. It's just that the assessor would never know about it if it stayed in the trust.
Right.
But continue.
That's my guess. It is a reassessable event legally. This is the way around it.
But it gets reevaluated at the current market value anyway. When you pass it off, when you pass.
Well, if you were to pass, there's a form called death of real property owner
Yes.
that the assessor has to get in the first 150 days after someone passes.
Right.
That is not always used for reassessment, depending on your county. But it is a notification of a death.
Right.
They have that option. We don't see it as much in Orange County. Los Angeles is a whole different animal. Questions? All right, so we're going to the second part of Prop 19. This was the generational wealth aspect. In the past, 4 kids, 4 houses, you deed them to your kids, you're good to go. Everybody's happy. They decided, it's funny, when we get bills passed, obviously the real estate industry and title and all of us have lobbyists and we're pretty strong. But we got the 3-time thing, and we got all the counties in California to cooperate. What we didn't get was unlimited generational wealth. So basically, in the past, I could deed my property to my child, and it was not a reassessable event. They have to verify socials and relationship, but overall, it was not a reassessable event. Now I can deed my property, but I have to live in it. My child has to live in it, and it cannot have a market value of more than $1 million.
Oh, I didn't know that.
Or it's $1 million
where-
of assessed value.
Well,
can be.
they'll do their assessment.
Yeah.
So that's where they put those restrictions on, right? It's the $1 million thing.
Make
Yes.
that a little bit more user-friendly. What you're saying now, as soon as it hits $1 million, then it's coming down to Proposition 19. The kid gets it.
If I want to deed my property, so my property is worth $900,000. I can deed it to my daughter, but she's going to have to declare that it's her primary residence and it must be mine. So let's take the scenario that we had of the 4 properties and the 4 kids. What technically I will have to do, if that's my scenario, is I will have to move in to the first one, 2 years. Then I deed it to that child. They move in. And it has a value of less than $1 million. And ideally, I'm doing that with each child 4 times. But the residency issue, the primary residence thing is significant. In the past, there was no proving that, there was no verification of that. That wasn't an element of those propositions.
What triggers it if it's in a trust? And how long can it stay in a trust?
Well, here's where the title guy, even though we agree on everything, we really do, actually,
Yeah.
it's brilliant. But I'm also that guy that's like, we don't want to poke the tiger, right? The assessor's the tiger. So lawyers almost always say record an affidavit of death of trustee. It's a recordable event. The assessor's going to look at it. I personally, the only requirement in the state of California is to be notified within 150 days with the assessor form of death of real property owner. Whether that is in a trust or whether it's held as an individual doesn't make any difference if you're a joint tenant or it's a trust. So I always suggest to not record that affidavit. You've already met your requirement by doing the form to the assessor in that first 150 days. I don't personally think that we should be recording affidavits of death in trusts because it does call attention to the situation. I don't know your thought on that.
Yeah, so I would say that it depends on the client's situation. And Terry, right? Yeah. So here's an example, which is generally speaking, right? As a lawyer, you're right. I do advise my clients, hey, if this is a reassessable event, sucks, but
Yeah.
it should be reassessed, right? And so,
Well, I didn't even know you had to do that.
yeah.
Notify
But
the
here's
assessor.
an example,
Nope.
right? So let's just say, and I'm not going to call this legal advice. Let's just say that this is not legal advice. Let's say that there's a client and they say, hey, mom died. she is holding. She had a trust. The assets are supposed to come to us kids, the 4 kids, outright, let's say. And I'm going to step over here so the folks in the back can hear me. We're just going to hold the assets in the trust. We'll leave it in mom's trust, so that the property taxes don't get reassessed. Okay. So we're not going to file an affidavit of death. We're not going to provide any notifications. It is what it is. Sometime later, right, comes time to sell the property or to refinance it. One of the kids wants to buy the other one out because who wants to own property with your 3 siblings that you don't even get along with, right? Now, time to pay the piper, right? We got to file an affidavit of death. We got to insert not Timmy, but Timmy's brother Joey as the trustee. Now we have to provide all the paperwork because the county's asking about, hey, we want to see a copy of the trust where all these assets going. What are the terms? Now we have back taxes.
You get a retroactive supplemental bill back to the death of the deceased.
Yeah. So
they're going to get you one way or another. It just depends on
so you're really
if you want to
playing
do
with
it up
fire
front
there.
or if you want to.
Yeah. So.
Well, and that's also, we get this a lot with bank accounts, right? As you know, we close escrow and the trust is you know, in the name of the trust, they put it in the trust bank account. And then as the trustee, you're supposed to make the distributions. Well, I always say, hold money in that account before distributions, okay? Because there is going to be a supplemental tax bill possibly that comes in and is retroactive to dad's death. There are things like that. Try getting that money back from your spouse, from your siblings, right? You've already made those distributions. So I'm of the ilk in Southern California, keep $40,000 pretty much back for at least a 2-year period. Because that way, if there's just stuff that trickles in, you're not going back after distributions and trying to do that accounting with siblings and everybody else, right?
Don't let the cow out of the barn.
Good. Question.
Is there a grace period to sell the property?
It really depends on what the heirs, and are we talking in a trust or outside?
Say it's in the trust.
Here's what we're seeing a lot of right now. This is an interesting phenomenon. It's brand new. Instead of they sell the property, but instead of taking all the distributions, they do a seller carryback. So now that dormant money that nobody really needs right now is now income, right? They've loaned it to the new buyer, and now they're getting payments.
But there's no supplemental asset.
No.
That's one way to avoid it.
Yes. Questions? And like I say, I've worked with some of you in here. I've had questions before because I kind of do all Kathy's stuff. But my name and numbers on everything. Like I say, every day. I deal with the assessor every day. You may or may deal with them twice in your lifetime. So just reach out. I will walk you through most of the cases when we're doing those Prop 19 forms, the transfer forms. I can do those and help you with that, and then you just have to sign them and do the pertinent, prove you're over 55, put your social in there, get a copy of your driver's license because they now verify that stuff. Anything else?
I have a question.
Yes.
In the trust is husband and wife, and then one of them passed. What happened after that? And they have all the assets in the trust.
In many estate plans, when a husband and a wife create a trust, they usually create it so that if one spouse is gone, the assets are still available for their surviving spouse, right? Now, we're not just giving it away to the kids and, taking away assets from the spouse that's still alive, right? So usually that's what's called like a I love you honey trust, right? If I die, everything goes to you. If you die, everything goes to me. Mm-hmm. If that's the case, then one spouse passes away, then the asset would the house would remain in trust for the benefit of the surviving spouse. That's not always the case, but I would say that's probably the most common outcome.
And the survivor can just write something, give it to the kids, or you have to have a new trust.
So it depends on how the trust is written, but generally speaking, if the survivor wanted to give that house to the kids and they were now the sole beneficial owner of the property, then yeah, it would be within their right to gift the property to their kids.
I have grandparents who left property in a trust to my mom and my uncle. They now want to leave those assets to me. How do I avoid tax, being hit with taxes?
As far as property taxes,
Yeah.
they do that through an amendment to the trust, right?
Maybe.
The good part, well, maybe. What I deal with, and the difference between Brian and I, is I only deal with on-record matters. I only deal with documents that are public. Okay, what the roadmap, which we call every trust has it's a roadmap of what you wanted to happen, and you'd be shocked. The roadmaps get really wild, and so sometimes it's not the spouse that's named as the successor trustee, or even the co-trustee. So in that situation, if they're going to make changes as far as distributions and beneficiaries and all that stuff, I would actually have to refer it to Brian. But my thing would be you do it as an amendment to the trust. You don't change the
That's
name
how
per
it
se.
would avoid me from. Okay.
It will depend on the terms of the trust, so and the facts of the situation, right? So the answer to your question is find a good estate planning attorney and have them review the trust and their situation and come up with a game plan. I know that's not a sexy answer, but that's probably the most legally accurate one.
Well, and I don't know if you covered this at the very beginning, but revisit your trust every 5 years, guys. When I did mine originally, my kid was, I think she was 10. So, everyone that was in charge was my brother. And now my kid's an attorney and my brother's passed away. So that would have been really a hassle for everyone involved had there not been updates. So, our lives change, and they changed more quickly than we really thought they would, right? So every 5 years is a good barometer of that. The players may change. There may be some more assets you're putting into the trust, things like that.
Yeah. Or if you have major life events, that's also a good time to review your estate. So, yes.
when my dad passed away, he had a bike.
All right, so Tammy brought up an interesting scenario, which is, her father's and his second wife created a trust. It's known as a bypass trust, or oftentimes it's referred to as an ABC trust. But what it's designed to do is it's designed that if one spouse dies, instead of, your example where it all just, honey, I love you, it says, hey, if I die, right, and let's say it's a blended family. So let's say husband has kids from prior marriage, and he's like, hey, if I do a I love you trust and I die first and all goes to my wife, what if she gets remarried again and decides she wants to leave all my assets to some new family that has no connection to my kids? So and what was your name? Tammy, that's right. Okay, so what they did was they said, okay, if I die, or if either spouse dies, the trust will split into two separate parts. One part for the survivor, the spouse that's still living, one part for the spouse that passed away. The purpose behind doing that is then to lock in the beneficiaries of the spouse that passed away first. So in this case, husband, if husband says, if I die first, we're locking up my assets so that you may be able to use them during the course of my lifetime, second wife. But when you die, these assets have to go to my kids, right? You can't just leave them to some third party, right? And so what happened in that situation is those assets were locked up for the benefit of, well, ironically, the second wife died first, but you were still listed as the beneficiaries, the 4 kids were. So her portion was set aside for the 4 kids so that when husband died, the third wife wasn't able to come after those assets. And so that's again, one cool example of how a trust can really adapt to situations that are, a little more complicated than, the honey, I love you, the functional marriage, nuclear family, right, with no blended issues and things like that. And so
It's California. Right?
Yeah, this is it. This is it. California.
I don't know
families.
anyone like that. Anyway.
So those are some examples of how a trust can be drafted in a way to address problems or complex family situations, right? And that's a fairly common one that pops up. So
I guess the synopsis, if we had to say this, don't do it yourself, okay? When it comes to trust, I get that question. Oh, there's one on LegalZoom. Don't do it. There's too many variables. It's California. Same thing with before you record a document of any kind, run it by me. Because we want it, people forget. I want to give my property to my kids. Can they do that without, now the kid gets the property, but the kid also now has,
Right.
you know, $1 million tax bill, right?
In a primary residence, one spouse died, the second spouse owns the property.
Okay.
Then when the second spouse also dies, then the property goes to it's in the trust.
Okay.
Property goes to the kid.
Successor trustee, whoever that is.
So the kid gets the house, but it's not his primary residence. How does the Prop 19 come into picture?
It doesn't. He's not 55 and it's not his primary residence. It doesn't play a role.
So, but it's not taxable event, right?
If they were to do it, again, if you execute a document and make it public, then the assessor looks at that scenario and they have the option of reassessing the property. The person that was taking advantage of the Prop 19 benefits, same thing with capital gains, same with all of this, right? It could be the trust, it could be an individual, it could be a couple. But all of those benefits go with that entity. If you mess with that entity, then it's a reassessable event.
Yeah, but the thing is that the death gets
no, it's a triggering event.
recorded
Yeah.
by the crematory or cemetery. So it's a public knowledge, and they do find out that the
Yeah, we're
certain
confusing
person
two
and the-
things. We're confusing, one is, will the assessor reassess? And does the reassessor deem it a reassessable event? So even if you have a trust, let's say that trust says it goes to your kids, you die, even if you leave the property, even if the trust itself says keep it in the trust for the benefit of my kids and don't distribute it to them,
Yeah.
that's still a reassessable event because the beneficial owners have changed. Now, will the county assessor ever find out about it? If a tree falls in the woods and no one's around to hear it, does it make a sound? Yeah, but to my point, right, is you can do that, but you're playing with fire because at some point you probably will need to do something with the title of the property and they will find out. So another example that pops up a lot is when we're dealing with LLCs. Anybody here know what an LLC is, or a limited liability company? So a limited liability company is another type of entity, right? It's a business entity, like a corporation. And a lot of times when people hold property in LLCs or corporations, right, there are different rules that govern when a triggering event is that a property would be reassessed. So for example, if I were to own a property in my name, right, Brian Chow, and then I gave you, Krishna, 50% of it, right? Then 50% of that property would be reassessed, right? Because you're not my child, and you're not living in the property as a primary residence, right? Now, let's say instead that we own that property, or I own that property in an LLC, right? And Terry, pay attention, because this is one way that you can mitigate some of these property tax issues. So, if I own that in an LLC and I gave you 50% of it, that's not a reassessable event, okay? And the reason why is because in LLC, the way that the Board of Equalization, I think, treats it is you can give up to 50% of an LLC, right, to somebody else, and and they don't consider that a change of ownership. So if I gave Krishna 50% of that LLC, not a reassessable event. You know what's also not reassessable is if we pull that LLC, of that property out of the LLC, and we own it in the exact same percentages that we owned the LLC. So now, right, Krishna and I own 50% of that LLC. We sign a deed. I'm the manager of the LLC. I sign a deed that says, I, Brian Chow, manager of Krish Chow Properties, right, transfer from that LLC out to Brian and Krishna 50-50 as tenants in common, right? We'll talk about tenants in common versus
No
joint
new
tenants.
parties,
Yeah.
no change. Just
Yeah,
the
it's
two of
exactly
you,
the same,
Exactly the same.
right? That's exempt from reassessment. So now I've transferred 50% of that property to Krishna, right? Without triggering a 50% reassessment of the property. And you can get even crazier with stuff like that. Terry's mind is turning, right?
LLC is really easy.
You
way
can
to
do all sorts
reassessment.
of fun stuff to mitigate property taxes utilizing strategies such as that, right? So
But if the LLC is in the trust,
doesn't matter.
Yeah, that's what I need to do.
Well, and then that the whole LLC thing becomes a game because it's about $1,600 a year you have to pay to the state of California to keep it current.
But wouldn't
every
you
year.
rather pay your attorney?
On special tonight
But again, if you've owned the property for a long time and it's a valuable property,
Yeah.
it's worth
Well
the
worth
risk. And if the county reassesses it, then we advise our clients. You know the risks. They can
I've-
just fold this whole thing up, but why not? It's a shot in the dark, right? Worst case scenario is to get reassessed, but
How
it can get
about,
reassessed.
how about an LLC with my daughter?
Yeah, you can do that.
but Prop 13 still applies, right?
Yeah, so it's not a Prop 13 issue, it's an LLC issue. So Prop 13 is a transfer between parent and child,
Yeah.
whereas you can do this with anybody with an LLC. Because Krishna, again, is not my progeny, right? It doesn't matter. Krishna could be my mailman. He could be, he's just somebody that I met at a speaking engagement, and we decided to co-own real estate together, right? It doesn't really matter. Yeah, you could be my daughter or whatever. Yeah, it's fine. Like it doesn't really matter. It could be my mailman, the milkman, the paper boy, or
I had those.
yeah. So
All right.
cool. Yes. Actually, in the back.
So,
And what was your name?
Bianca,
Bianca. Nice
Yes.
to meet you.
so as far as the LLC, that only applies to California or is that nationwide?
It applies. The question is, does the LLC transfer apply only in California or nationwide? The answer is it only really matters in California because California is the only state that has this particular property tax regime. So the reason why Terry and people like Terry, including myself, are crazy about property taxes is because California has this thing called Prop 13, which Kevin alluded to before, which is back in the 70s, Southern California became a really popular place to live, right? So a lot of people were moving to California, and the way property taxes are typically assessed is they usually take a percentage of the fair market value of the property. But if you can imagine in California where properties were increasing, 10, 15, 20% year over year, there were a lot of people in California, especially older, right, senior citizens living on a fixed income, that were like, this is crazy, we can't afford to live here, what the heck? So they passed a proposition called Prop 13, which said, we're gonna limit the amount that the property can increase per year to 2% of the base, right? So now where the properties are increasing like this, right? The assessed value of the property is actually increasing like this, right? So what happens is over time, the property tax, the assessed value, the amount on the taxpayer roll is a lot lower than the actual fair market value of the property, right? So what happens then is that's why people go to all these lengths to keep the property tax basis low. Because they're like, dude, I've owned this thing for 40 years. It's now a $2 million property. I bought it for $40,000, right? I'm gonna do everything. I'm gonna do everything that I possibly can to keep that property tax basis low. Whereas in other states like Texas or New Jersey, they're just like, screw you. Like it's 1% of the fair market value, no matter how much it grows, right? And so for most states, it doesn't really matter. But in California is unique, as if we didn't know that we were unique already. From a property tax perspective, it's unique because property taxes, the longer you own it, the more artificially depressed your property tax basis
Because
is.
of the cap.
Because of Prop 13.
So it only really applies. It's only really an issue in California. If you don't want to deal with Prop 19, move to Ohio.
The But California does not.
or Nevada.
California
Don't
does
take a
not
trip.
have a state tax, right?
Huh?
California does not have a state tax.
Yeah, so the question Krishna has, Krishna's got all the questions there. Krishna, right, is saying, does California not have an estate tax? The answer is California does not officially have an estate tax, which is great, right? Because some states do have their own version of the estate tax, like Washington, New York, right? They have estate taxes that they apply on top of the federal estate tax. However, California does share in a percentage of the revenue that the federal government collects for estate taxes. Because guess what? We have all the rich people that pay the estate tax. That's why. So, okay, Noemi.
Now, if, for example, I want to sell the house, and the house.
Your house.
Yeah, but the house gets sold, and the escrow says, here is your check, and they put state. Same thing was happening now to me. If they put state of
The
Rochester,
estate of?
so
yeah.
how do I cash that check?
Yeah, so, well, first of all, Noemi, again, it depends on the facts of your situation, but my guess is you probably co-own your house with your husband as joint tenants, right? Husband and wife as joint tenants, or maybe the two of you as trustees of your trust, right?
I
Most likely.
remember more trustee, but I think I see in the trust that we have, joint.
Yeah, if you look on the title to your real estate, if I saw the deed to your house, I could probably tell you. But generally speaking, my guess is you have some version of an I love you trust with your husband, and maybe you guys are both trustees, or you guys own it as joint tenants. And so if that's the case, then we would just file an affidavit of death to remove him from title. You would then remain the sole person on title, and then you would be able to sell
And then the
property.
proceeds would come to you.
Otherwise, they're going to say you had to share with your husband, and I go, well,
No,
you got to
yeah.
send him.
Typically no. Typically no, but again, it depends on the specific
Buy
facts.
lovely flowers and leave.
So, but I would say it's less. My guess is if your situation, based on my experience, that is not likely to be an issue. But again.
Yes.
When you're establishing a trust and you have a residence already and you want to put it into the trust, is that a necessity?
Yes. No, actually.
It depends.
It's not, well, again.
It
This is
depends
why
on
we
the
never
terms
do
of the
this
trust.
with lawyers. So, technically, when we go from you to your family trust, the assessor wants a verification that the entity is run by the same people. Okay, so normally they're going to ask that question: either give us a copy of your trust or give us the trust cert, whatever. And I'm going to say Orange County, they really don't do that, and LA they do.
You mind if I add my 2 cents there?
Please.
So there's a specific. So your question and the question that Nick had was, if I have a trust or if I have a house already and I create a trust and I want to put that property into the trust, is that a reassessable event? The answer, as we all know, is it depends, right? But for most people, what you have is you have what's called an everyday revocable living trust or a mom and pop trust, right? And so the way that the trust is drafted is that you're the beneficiary of that trust, which means that everything that's in the trust is held for your benefit, okay? So when you file the deed to transfer the property into the trust, you're gonna say something like, Nick Garcia? No?
You'll never guess.
All right, Nick, we'll just say Nick. Nick hereby transfers the property to Nick as trustee of the Nick Family Trust, all right? So along with that, you're gonna file a form, or your attorney will draft it for you, which we do all the time, called a preliminary change of ownership report, okay? Or a PCOR. Essentially what that is a addendum that gets filed along with your deed that lets the county assessor know what the heck is going on, okay? And on that deed are a list of scenarios that you check, right? Is this a lease of 35 years or less? Is this a transfer between parent and child? So the question is, if you are a trustee of a trust, that trust holds some real estate, you want to add additional trustees to the trust, does that cause a reassessment, or is that an issue from a property tax perspective? The answer is no. And this is really important because the trustee is just the steward of the assets, not the beneficial owner of the assets. So if the Nick Family Trust continues to say these assets are for the benefit of Nick, but we're going to add Ivy as a co-trustee to manage these assets for the benefit of Nick, the ultimate person for whose benefit those assets are being held is still Nick, right? So there's no reassessment. If you change the trust to amend it to add Ivy as a beneficiary of the trust while you're still alive, that could potentially be a reassessable event, provided that Ivy was not your spouse or some other exempt party. So if you wanted to avoid property tax reassessment, Terry, and this is a lawyer joke, but you could marry your daughter. And that would prevent reassessment. And this is the type of legal advice you can expect if you call me. So please call me.
Hey guys, we appreciate your time very, very much. We'll hang out if there's questions. And have a great evening.
Yep.
Thanks for having us.
Thanks, guys. Thank you for having us.
Good job, Brian. Excellent job.